These provisions are consistent favorites of bar examiners in remedial law. Each has been asked more than 5 times, and some have appeared over 10 times or more. There is a reason they keep coming up. I know you've encountered these rules before, but I want you to focus on these codal provisions with precision. Examine them carefully. Break them down word by word. Dissect them like a scientist. Know them by heart. Rules of Evidence. The Revised Rules on Evidence. Rule 128. General Provisions. Section 3. Admissibility of evidence. Evidence is admissible when it is relevant to the issue and is not excluded by the Constitution, the law, or these rules. Rule 129. What need not be proved. Section 2. Judicial notice when discretionary. A court may take judicial notice of matters which are of public knowledge, or are capable of unquestionable demonstration, or ought to be known to judges because of their judicial functions. Rule 130. Rules of Admissibility. B. Documentary Evidence. Section 2. Documentary Evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of their contents. Photographs include still pictures, drawings, stored images, X-ray films, motion pictures, or videos. 1. Original Document Rule. Section 3. Original document must be produced. Exceptions. When the subject of inquiry is the contents of a document, writing, recording, photograph, or other record, no evidence is admissible other than the original document itself, except in the following cases. A. When the original is lost or destroyed or cannot be produced in court, without bad faith on the part of the offeror. B. When the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedures. C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time and the fact sought to be established from them is only the general result of the whole. D. When the original is a public record in the custody of a public officer or is recorded in a public office. And E. When the original is not closely related to a controlling issue. Section 4. Original of Document. A. An original of a document is the document itself or any counterpart intended to have the same effect by a person executing or issuing it. An original of a photograph includes the negative or any print therefrom. If data is stored in a computer or similar device, any printout or other output readable by sight or other means, shown to reflect the data accurately, is an original. B. A duplicate is a counterpart produced by the same impression as the original, or from the same matrix, or by means of photography, including enlargements and miniatures, or by mechanical or electronic re-recording, or by chemical reproduction, or by other equivalent techniques which accurately reproduce the original. C. A duplicate is admissible to the same extent as an original unless 1. A genuine question is raised as to the authenticity of the original, or 2. In the circumstances, it is unjust or inequitable to admit the duplicate in lieu of the original. 2. Secondary Evidence. Section 5. When original document is unavailable. When the original document has been lost or destroyed or cannot be produced in court, the offeror, upon proof of its execution or existence and the cause of its unavailability without bad faith on his or her part, may prove its contents by a copy, or by recital of its contents in some authentic document, or by the testimony of witnesses in the order stated. C. Testimonial Evidence. 1. Qualification of Witnesses. Section 21. Witnesses, their qualifications. All persons who can perceive and perceiving, can make known their perception to others, may be witnesses. Section 22. Testimony confined to personal knowledge. A witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her own perception. Section 23. Disqualification by reason of marriage. During their marriage, the husband or the wife cannot testify against the other without the consent of the affected spouse, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants. Section 24. Disqualification by reason of privileged communication or communications. The following persons cannot testify as to matters learned in confidence in the following cases. A. The husband or the wife, during or after the marriage, cannot be examined without the consent of the other as to any communication received in confidence by one from the other during the marriage except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants. B. An attorney or person reasonably believed by the client to be licensed to engage in the practice of law cannot, without the consent of the client, be examined as to any communication made by the client to him or her, or his or her advice given thereon in the course of, or with a view to professional employment, nor can an attorney's secretary, stenographer, or clerk, or other persons assisting the attorney be examined without the consent of the client and his or her employer, concerning any fact the knowledge of which has been acquired in such capacity, except in the following cases. 1. Furtherance of crime or fraud. If the services or advice of the lawyer were sought or obtained to enable or aid anyone to commit or plan to commit what the client knew or reasonably should have known to be a crime or fraud. 2. Claimants through same deceased client. As to a communication relevant to an issue between parties who claim through the same deceased client, regardless of whether the claims are by testate or intestate or by inter vivos transaction. 3. Breach of duty by lawyer or client. As to a communication relevant to an issue of breach of duty by the lawyer to his or her client, or by the client to his or her lawyer. 4. Document attested by the lawyer. As to a communication relevant to an issue concerning an attested document to which the lawyer is an attesting witness. Or 5. Joint clients. As to a communication relevant to a matter of common interest between two or more clients if the communication was made by any of them to a lawyer retained or consulted in common, when offered in an action between any of the clients, unless they have expressly agreed otherwise. C. A physician, psychotherapist or person reasonably believed by the patient to be authorized to practice medicine or psychotherapy cannot in a civil case, without the consent of the patient, be examined as to any confidential communication made for the purpose of diagnosis or treatment of the patient's physical, mental or emotional condition, including alcohol or drug addiction, between the patient and his or her physician or psychotherapist. This privilege also applies to persons, including members of the patient's family, who have participated in the diagnosis or treatment of the patient under the direction of the physician or psychotherapist. A psychotherapist is A. A person licensed to practice medicine engaged in the diagnosis or treatment of a mental or emotional condition, or B. A person licensed as a psychologist by the government while similarly engaged. D. A minister, priest or person reasonably believed to be so cannot, without the consent of the affected person, be examined as to any communication or confession made to or any advice given by him or her, in his or her professional character, in the course of discipline enjoined by the church to which the minister or priest belongs. E. A public officer cannot be examined during or after his or her tenure as to communications made to him or her in official confidence, when the court finds that the public interest would suffer by the disclosure. The communication shall remain privileged, even in the hands of a third person who may have obtained the information, provided that the original parties to the communication took reasonable precaution to protect its confidentiality. 6. Exceptions to the hearsay rule. Section 38. Dying declaration. The declaration of a dying person, made under the consciousness of an impending death, may be received in any case wherein his or her death is the subject of inquiry, as evidence of the cause and surrounding circumstances of such death. Section 44. Part of the res gesti. Statements made by a person while a startling occurrence is taking place or immediately prior or subsequent thereto, under the stress of excitement caused by the occurrence with respect to the circumstances thereof, may be given in evidence as part of the res gesti. So also statements accompanying an equivocal act material to the issue, and giving it a legal significance, may be received as part of the resigesti. Section 50. Residual exception. A statement not specifically covered by any of the foregoing exceptions, having equivalent circumstantial guarantees of trustworthiness, is admissible if the court determines that a. the statement is offered as evidence of a material fact, b. the statement is more probative on the point for which it is offered than any other evidence which the proponent can procure through reasonable efforts, and c. the general purposes of these rules and the interests of justice will be best served by admission of the statement into evidence. However, a statement may not be admitted under this exception unless the proponent makes known to the adverse party, sufficiently in advance of the hearing, or by the pretrial stage in the case of a trial of the main case, to provide the adverse party with a fair opportunity to prepare to meet it, the proponent's intention to offer the statement and the particulars of it, including the name and address of the declarant. 7. Opinion Rule. Section 51. General Rule. The opinion of a witness is not admissible, except as indicated in the following sections. Section 52. Opinion of expert witness. The opinion of a witness on a matter requiring special knowledge, skill, experience, training or education which he or she is shown to possess, may be received in evidence. Section 53. Opinion of ordinary witnesses. The opinion of a witness, for which proper basis is given, may be received in evidence regarding a. the identity of a person about whom he or she has adequate knowledge, b. a handwriting with which he or she has sufficient familiarity, and c. the mental sanity of a person with whom he or she is sufficiently acquainted. The witness may also testify on his or her impressions of the emotion, behavior, condition or appearance of a person.